Oh, thank you. Thank you very much. I think CISO has actually covered the COVID and the challenges that we face quite in detail. So I'm not going to repeat whatever CISO has said. However, I must say that this COVID has taken over, and it's now not business as usual; it's business unusual. So on that note, I'd like to start my presentation. I must give a big disclaimer here. These slides were actually compiled by one of my associates, and I'm not familiar with presentations, but I will try my best, and let's see how we go. All right, so I think everybody knows that the buzzword is business rescue at the moment, as it's going around with regards to SAA, Highfeld Steel, Edcon. There's a lot of talk about business rescue. And also there's a global trend towards business rescue of companies in the that's in financial distress. More especially, there's an emphasis placed on not putting companies or placing companies in liquidation for obvious reasons. In South Africa, business rescue has become part of the legal landscape when it was introduced in Chapter 6 of the New Companies Act 2008, Act 71 of 2008. And Chapter 6 provides for the efficient rescue and recovery of financially distressed companies in a manner that balances the rights and interests of all stakeholders. Now, what I'm going to do is I'm going to go through business rescue informally. The slides are very, very formal because there's strict compliance in terms of the Companies Act Chapter 6 on business rescue. So the statutory requirements are very, very, very strict. And that is the reason for these slides, so that you understand. But I am not going to go through the slides as it is illustrated in this webinar. Okay, so let me start. Thank you, Gary. And now you can go to the next screen. Okay, so basically what it provides is the temporary supervision of the company and the management of its affairs by a business rescue practitioner. And most importantly, the temporary moratorium on the stay of claimants against the company in respect of property in its possession. So basically what that means is that once you go into business rescue, there is a moratorium placed on any action that will ensue against a company, which means that if there is litigation that's going to be, or there's going to be a claim against your company, once you get into business rescue, that whole process is stayed. In that process, there is also a provision where there has to be a plan developed by the business rescue practitioner, approved by all affected persons, which has to be and then implemented in restructuring a business so that the business can actually continue to function and to remain in business. Next slide, please, Gary. Gary, next slide, please. Okay, so basically, we basically covered what the aim of the business rescue is. However, I just want to state the main purpose of the business rescue proceedings is to provide a company or a close corporation with a temporary supervision and protection against its creditors. This actually gives some sort of breathing space. So you don't have to worry about paying your creditors, but what you can do is you can actually use the time, that monies and services in order to reorganize and restructure the business and its affairs so that it can continue operating. In fact, it is similar to the US Chapter 11 bankruptcy protection provisions in US, like I said. Okay, so that moratorium gives all the companies pre-business rescue creditors, actually gives them, it ring fences them. for the duration of the rescue proceedings, which obviously will be outlined in the business rescue plan. Next slide, please, Gary. Okay, so the main, I've given you the main advantage, which is basically the moratorium and breathing space. The main disadvantage is, though, a business rescue proceeding, once it's entered into, it may actually affect the company in getting finance for obvious reasons, or getting working capital, or getting goods and services delivered. However, there is provisions also made in the Act in terms of post-commencement finance, which I wouldn't deal, which I'll deal briefly now. I don't deal with it in my slides. So the post-commencement finance assists the company by placing its assets that are unencumbered as guarantee for finance. And that creditor who actually loans those monies become a preferred creditor. So there is provisions where you can actually get such funding. Right. So to go back to the slide, what is a business rescue practitioner? A business rescue practitioner is a person appointed to oversee a company during business rescue. Right. Such person must be suitably qualified. So it could either be in the legal profession, which is a lawyer, an accountant, probably a CA, or a business consultant who has been familiar with turnaround strategies. Also can be licensed by the CIPC, and the practitioner must be affiliated or registered with a regulatory body. So there is some sort of compliance, and there are checks and balances that the business rescue practitioner will basically do what he needs to do. Right? There's other provisions in the sections as well, that they must have no conflicting interests, they must have no relationships to the businesses in any way whatsoever. So those are basically the requirements for being a business rescue practitioner. Incidentally, I am a business rescue practitioner, and I am licensed as well. So anyway, let's go on. What is an affected person? So if you would see on the slide, there's internal stakeholders and external stakeholders, and all of them have various rights, right? So so if we look at the internal stakeholders, when a company goes into business rescue, all the employees' contracts remain intact. There's no change unless the business rescue plan makes provisions for that, and that obviously will have to be approved by the necessary stakeholders. The external stakeholders are as illustrated. However, I must say government is an important one, which includes SARS. So any one of these stakeholders have an opportunity to bring an application, which I will discuss shortly, to bring an application for a business rescue on a company. Next slide, please, Gary. Okay, so this is a big question. What is the test for business rescue? The test for whether or not a company should be placed in business rescue is whether or not the company is financially distressed. And the Act defines the word financially distressed. So financially distressed means if it appears to be reasonably unlikely that the company will be able to pay off all its debts as they become due and payable within the immediate ensuing 6 months, which means that if somebody presents you an invoice and you are not able to, or your company is not able to pay that, you are financially distressed. Looking at this period of time, the COVID pandemic and the lockdown has actually placed us in, a number of companies are in financial distress now. And for that reason, they should consider business rescue, because it places that moratorium on any action being taken against the company or any claims being made against the company. Then the next provision that, the next part of the definition is, if it appears to be reasonably likely that the company will become insolvent within the immediate ensuing 6 months, which is actually a factual. So if you look at your debts and your liabilities, and you think that, you know, your balance sheet is not looking great, the company would be, in fact, insolvent in a few months' time, well, basically 6 months, then you should consider making application for business rescue. Next slide, please, Gary. Okay, so this slide is basically to illustrate the headaches and obviously the fall of the company. Can we proceed to the next slide? Okay, how is a company placed in business rescue? Okay, the Act provides two main ways in which it can be placed into business rescue. One is voluntarily, and the other one is by court order. Okay, so in terms of Section 129, as the Act provides, when the board of directors of a company resolves that the company voluntarily commences business rescue proceedings. So when the board obviously realizes that they're in financial distress for the reasons that we discussed earlier, they may make an application with the CIPC for voluntary business rescue. Or when an affected person that we've identified earlier makes a formal application to the court for an order placing the company under supervision and commencing business rescue proceedings. The other ways that a company should actually make an application for business rescue is when the company is financially distressed, and the company has failed to pay over any amount in terms of an obligation under or in terms of a public regulation or contract with respect to the employment-related matters. That day, I gave an example of SARS. So if you don't pay your UIF or your taxes, or then and in respect of employment, then obviously the company can be placed into business rescue. Or if it's just and equitable to do so for financial reasons, you know, that the company is in fact going to be insolvent. Can we move on? Gary? Next slide. Okay, so the voluntary process, how does it commence? Okay, so this is quite academic. I'll just go with very, very briefly. There are certain forms that needs to be filled in with the CIPC, but most importantly, a resolution of the board of directors has to be filed with that, together with the if the company has a business rescue practitioner in mind, they can actually choose their own business rescue practitioner, so they can make that together with the resolution and with a statement setting out the facts upon which the resolution was founded, which means that the company is in financial distress. And thereafter, there's a lot of prescribed sections that has to be followed in order to make the voluntary application with CIPC. Next slide, please, Gary. Okay, this is very, very academic, but I've got it in here just to give more theory into what actually goes into the business rescue application on a voluntary basis, and the strict compliance with regards to the notices and business days that has to be complied with. If the dates or the days have not been complied with, we run the risk of that business rescue proceedings becoming a nullity, which means that it will go out of business rescue, and obviously the moratoriums that stay in any proceedings will fall away. So your company is vulnerable again. So these are just for academic purposes and for you to go through in your own time. Can we go to the next slide? Okay, what happens if the time periods are not adhered to? I have explained that already. So we can move on to the next slide, please, Gary. Sorry, I must make one mention of, sorry, can we go back to the previous slide? I just want to make one point here. You see 3 months to reapply. What happens if there is, for any reason, non-compliance with any one of the time periods? The company cannot rectify it immediately. It has to stop the process and then only apply after 3 months has expired. So that's the only time you get to reapply. Within that 3 months, if there is any proceedings against that company, it can be pursued. So you just need to bear that in mind. Okay, so if we can go on to the next slide. Okay, so there's a number of objections. I mean, there's a number of ways of objecting a resolution that has been passed for business rescue. More often than not, it'll be by an affected person, right? So if you look at this slide, there's a lot of information, but it's all academic, and it's we'll discuss it if you need to discuss it at a later stage, you can contact me, but it's actually quite strict compliance on who can bring their application and what the reasons for bringing their application are, and who can participate in hearings, if the directors have voted, and when they can bring an application or when they cannot. So if we can, like I said, it's pure academic. If we can move on to the next slide. Okay, so basically we've dealt with the voluntary process of making an application, and that's by the company and a board resolution. However, if an affected person makes an application, that has to be done in a court process by way of application. And what the application must contain is a number of reasons why the company can be actually rescued, or can go into business rescue, or can be rescued, and what the success will be. So this decision of the Western Cape High Court of Southern Palace Investment versus Midnight Storm Investment basically gave a detailed account of what can be put before the court in the application, so that the application would be successful for an affected person bringing an application for business rescue of the company. Okay, if we go on to the next slide. Next slide, please, Gary. Okay, how does one oppose a business rescue application to court? It's by way of application, so there's an answering affidavit if you want to, if you're the company and you want to oppose the application, then it's basically a court process where you have to serve and file your intention to oppose, and set down an answering affidavit of why you think that the company should not go into business rescue. This may be brought by a creditor, it may be brought by an employee, it can be brought by any affected person. All right, if we move on to the next slide. Okay, how long do business rescue proceedings last? Okay, the Act states it should be for a period of 3 months, but that's actually not very practical, because by the time the business rescue practitioner goes in there, identifies the problems, and implement or get a plan approved and implemented, most of the strategies are over 3 months. So it's actually not a practical period of time, but you can go longer than that. I think the reasonable time for business and most business rescues is between 6 to 18 months. So what the business rescue practitioner will do is convene meetings with all the affected persons, does his consultation on the plan, implements the plan, and if the proceedings have not ended within 3 months, he can you can make an application to court to allow him further time, or you can prepare a report on the progress of the business rescue proceedings, and every month send to each affected person a report on that. We made a mention here that the reporting requirements that come with extending the timeframes are burdensome, which is correct. And therefore, the business rescue practitioner generally tries to comply within that time periods, or the shortest time possible. But like I said, if he continues over the 3-month period, then obviously he'll have to report every month to all affected persons, CIPC, or if it was by way of court order, to the court. Can we go on to the next slide, please? Okay, when does it begin? So, also strict compliance when the company files a resolution to place itself under supervision, or a court. It applies to court for consent to file a resolution in terms of Section 129. And then, if a person applies to court for an order placing the company under supervision in terms of the sections of the Act, or a court makes an order placing a company under supervision during the course of liquidation proceedings. So when the last point of here, it says a court makes an order placing a company under supervision during the course of liquidation processes. If an application is made and the courts think it'll be better to revive the company or to survive the company, then it can actually bring a company out of a liquidation process and bring it into a business rescue process. So the court can make that appropriate order. In that event, then the liquidator will become a creditor to the business rescue practitioner. Okay, if that makes any sense. Can we go on to the next slide, please? Okay, how the process unfolds. If you look at it, it basically says practitioner must investigate the affairs of the company as soon as possible. That's in terms of Section 131. He must convene a meeting of the creditors and meeting of the employees. And he must advise them of what the prospect is of rescuing the company. The business rescue plan must be published within 25 days from his appointment, and the business rescue practitioner must convene a meeting of creditors who have, and any other holders who have voting interests, like the shareholders of the company, for the purposes of considering the proposed plan within 10 days, and then he must publish the plan. All right, if we can move on to the next slide. Okay, when does the proceedings end? It ends when, and it's actually straightforward. It says when the court sets aside the resolution or order, the court converts business rescue proceedings into liquidation proceedings. Okay, so in this point here, if for example, a company has only one client, and that client has terminated the contract, or that client does not require the goods or services, or that company has gone into liquidation for any reason whatsoever, and the company cannot find a way to restructure or to continue with business, then that business rescue proceeding must go into a liquidation process, because the company cannot survive. So that's when an application will be made to court to say, you know what, there's no prospect of the business rescue actually being successful, and therefore this company can go into liquidation. The next point is when the business rescue practitioner files a notice to say that, you know, a plan has been proposed and rejected, and therefore it cannot be implemented, and therefore the business rescue proceedings will terminate. And lastly, when the business rescue plan has been adopted and the business rescue practitioner has subsequently filed a notice of substantial implementation of the form, which means that he has implemented the plan and they have restructured the company. All right, so if we can go on to the next slide. Next slide, please, Gary. Okay, this year I thought was important to actually include because it's still a gray area. I'm not sure whether there's strict compliance to it or not. But what happens if a company does not commence with rescue proceedings when it should? If a company is in financial, I'm going to read through, so and then try and explain. If a company is financially distressed within the meaning of the Act, but the board of directors has not passed a resolution for the commencement of business rescue proceedings, then the board must deliver a written notice to each affected person, setting out the test for financial distress and the reasons why the board has not passed a resolution for the commencement of the business rescue proceedings. So basically, if the company or the directors are aware that the company is in financial distress, in terms of this notice, the Section 129 notice, they must give each and every affected person, as we discussed, the internal and the external affected person, a notice of its decision why it did not begin with business rescue. Now it's very, very peculiar, because if you read the next paragraph, it says a decision to send out a Section 129.7 notice must be well considered and exercised with caution, as such a notice advises the world at large that the company is financially distressed and on the verge of insolvency. This notice may give rise to a number of unintended consequences, both in respect of directors and creditors of the company. But furthermore, if you're applying for capital, if you're applying for goods and services, and if you have a facility, the people that you are, or the companies that you are dealing with, they may not provide you with the goods and services, and they may not enable you to continue operations as normal in your business. So therefore, I say it's a bit of an anomaly, in my opinion. But let's see what happens as we go along. If you can go to the next slide. Okay, so in summary, I just put a summary of what we've discussed earlier. Now, like I said, business rescue, there's strict compliance to the Act. So each and every section of the Act has to be strictly adhered to. But in a nutshell, it provides businesses with an opportunity of avoiding a liquidation process. Generally, companies being put into liquidation will result in immediate loss of ability to generate income, which means they wouldn't be profitable. Employees will lose their jobs. Communities, if the company is large that supports huge communities, the communities may feel the brunt of that. And therefore, it's important that a provision like the business rescue provision is in place, because it is aimed at restructuring the affairs of a company, that it can actually maximize the likelihood of the company continuing to be in existence and to stay solvent on a solvent basis, to retaining those jobs, to assisting those communities, to helping the economy grow. And if all that fails, then it also helps to produce a better return for the creditors of the company than would ordinarily result from the liquidation of a company. I think South Africa has a culture where if a company is failing, they go straight into liquidation, and whatever the liquidator can recover by selling off assets, which may be of an appittance, it will be sold off, and the company will not be non-existent. However, with business rescue, you can actually negotiate, the assets to be sold, or you can negotiate for the company to be sold or to be taken over by a competitor. There is huge possibilities when the company is in business rescue as compared to a company going into final liquidation. To go on, it provides for the temporary supervision of the company by a business rescue practitioner, a stay of rights of claimants against the company, which arose prior to the business rescue or in respect of property in its possession, and the development and implementation, if approved, of a business rescue plan to rescue the company by restructuring its businesses, property, debt, affairs, other liabilities, and equity. And then I must also add that all affected persons actually have a say in the planning of that business rescue plan, or they have a say in the business rescue plan. So it is the benefit of all parties to actually consider business rescue before the company goes into liquidation, into final liquidation. There's also one advantage in respect to business rescue and the business rescue practitioner. The business rescue practitioner, with all his vast experience and having a regulatory body, or belonging to a regulatory body, and having the experience and in his field of business turnaround, he takes control of that company and basically steps of the board and makes decisions very objectively. There's no emotional decision because he's coming from the outside. When I say he, I also mean she. So, somebody with a fresh pair of eyes, somebody with an analytical capability, and somebody with a knowledge of how to restructure, how to negotiate, how to mitigate risk, may be an opportunity for this company to get somebody totally from the outside to actually look at their business and obviously to restructure the company. Saying that, right now in the current circumstances that we find ourselves in, I think a number of companies will be in financial distress, and therefore I think it's a very appropriate topic to actually discuss at this moment and to consider in this point of time. Thank you, Gary.